Good afternoon, everyone, inside and outside the courtroom. Before we start, and pursuant to my decision setting the date for this initial appearance, the photographers are allowed to take a few photos for 1.5 minutes, and I will ask you not to make any pictures of the accused with the security guard. So if you can focus on the accused for the pictures you're going to take on this side. Thank you. Please proceed. Thank you very much. Madam Court Officer, could you please call the case?
This is case KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Veseli, Recep Selimi, and Jakub Krasnici.
Thank you very much, Madam Court Officer. Before asking those present in the courtroom to introduce themselves, I would like to remind everyone of a few rules that must be observed at all times in order to make courtroom proceedings smooth. Please make sure you activate your microphone before speaking and you switch it off as soon as you finish. Talk slowly and clearly as we have interpretation from and into Albanian and Serbian. Wait 5 seconds before responding to me or a party or participant in order to allow the interpreters to finish the interpretation. What is said in this hearing is transcribed in real time and will be reflected in a transcript available to the parties and to the public after this hearing. I would also like to remind the parties that certain information in this case is subject to protective measures and confidentiality orders. This includes confidential information that has been redacted from the confirmed indictment as to the identity of certain individuals, dates, locations, and other information. Confidential information shall not be disclosed in open session. If any party or participant must go into private session or refer to any confidential information, please indicate the reasons. Now, I would kindly ask the parties and participant to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor.
Thank you, Your Honor, and good afternoon to all in the courtroom and remotely. Appearing on behalf of the Specialist Prosecutor's Office today are Specialist Prosecutor Jack Smith, Deputy Specialist Prosecutor Alex Whiting, Head of the Legal Advisory Unit Claire Lawson, Prosecutor David Harbach, and I am Senior Prosecutor Alan Teeger.
Thank you very much, Mr. Prosecutor. Now I turn to the defense, please.
On behalf of Kadri Veseli, Mr. Veseli is represented today by myself, Ben Emerson, Queen's Counsel, and by my co-counsel, Andrew Cayley, Queen's Counsel, who is in courtroom with you today.
Thank you very much, Mr. Emerson. If at any time of this hearing you have a problem with the connection, please inform us immediately so that we can try to fix the problem. And I would adjourn the hearing if there was any major problem and if the communication was cut. And
I'm very grateful.
Thank you. And I also note for the record that your client, Mr. Veseli, is present in the courtroom. Now I turn to Madam Registrar, please.
Good afternoon, Your Honour. Fidel Madonlan, Registrar.
Thank you, Madam Registrar. And for the record, I am Nicholas Guillou, pretrial judge for this case. The accused is appearing today for the first time before the specialist chambers, following the indictment confirmed against him. Mr. Veseli, would you please rise? Could you tell us your full name?
Mirdita.
Good afternoon, Your Honor. I am Kadri Veseli. I was born on 31st of May 1967 in Mitrovica, Kosovo. Republic of Kosovo.
Let me now move to the procedural history of the case. On 26 October 2020, in my capacity as pretrial judge, I confirmed the indictment submitted by the specialist prosecutor against the accused, charging him with 6 counts of crimes against humanity, namely persecution, imprisonment, other inhumane acts, torture, murder, and enforced disappearance of persons, and charging him with 4 counts of war crimes, namely arbitrary detention, cruel treatment, torture, and murder. The accused was arrested in Kosovo on 5 November 2020, and he was transferred to the detention facilities of the Kosovo Specialist Chambers in The Hague on the same day. Mr. Veseli, before we proceed any further, I have to make sure that you can follow the proceedings in a language that you understand and speak. Can you confirm that you understand and speak Albanian?
Yes, Your Honor.
By this, I am satisfied that you can follow the proceedings in Albanian, a language that you understand and speak in accordance with Rule 92 of the Rules of Procedure and Evidence. If at any moment in the course of the proceedings you are not receiving interpretation, or if there is any problem in the interpretation, please draw my attention to it immediately. Now, allow me to explain the specific purposes of the initial appearance for the benefit of the accused, of those joining us in the public gallery, and those following the proceedings online. Today's hearing is not a trial. No evidence will be presented or debated, and the guilt or innocence of the accused will not be discussed or decided. The purpose of this initial appearance is regulated by Article 39 of the law and Rule 92. According to these provisions, as pretrial judge, I shall have the charges in the confirmed indictment read to the accused in a language he understands and speaks. Confirm that the accused understands the indictment. Satisfy myself that the rights of the accused, in particular his right to counsel, are respected. Inform the accused that within 30 days of today's hearing, he will be called upon to admit guilt or to plead not guilty on each charge set out in the indictment. If the accused wishes to do so, he may immediately admit guilt or plead not guilty. And finally, I shall also set other dates as appropriate in performing my functions as pretrial judge. I expect the parties to adhere to these matters, which I will address in turn. Should either party wish to discuss any other matter not expressively foreseen in the context of the initial appearance, they're invited to do so in writing by making a filing before me. First, may I ask you, Mr. Veseli, to confirm that you have received the confirmed indictment dated 4 November 2020 in a language that you understand and speak.
Yes.
Mr. Veseli, I will now ask Madam Court Officer to read out the charges in the confirmed indictment as foreseen in Article 39 of the law and Rule 92. Madam Court Officer.
Thank you, Your Honor. 1. In the confirmed indictment, the specialist prosecutor charges Mr. Kadri Veseli with Count 1, the crime against humanity of persecution punishable under Article 13(1)(h) of the law. Count 2, the crime against humanity of imprisonment punishable under Article 13(1)(e) of the law. Count 3, the war crime of arbitrary detention punishable under Article 14(1)(c) of the law. Count 4, the crime against humanity of other inhumane acts punishable under Article 13(1)(j) of the law. Count 5, the war crime of cruel treatment punishable under Article 14(1)(ci) of the law. Count 6, the crime against humanity of torture punishable under Article 13(1)(f) of the law. Count 7, the war crime of torture punishable under Article 14(1)(ci) of the law. Count 8, the crime against humanity of murder punishable under Article 13(1)(a) of the law. Count 9, the war crime of murder punishable under Article 14(1)(ci) of the law. And count 10, the crime against humanity of enforced disappearance of persons punishable under Article 13(1)(i) of the law. 2. These crimes were committed between approximately April 1998 and August 1999 at a number of locations in Kosovo and northern Albania, including Bare, Bajgore, Lapaštice, Majac, Potok and other locations in Podujeve municipality, Drenok and other locations in Rahovec municipality, Beriše Mountains, Lapušnik and other locations in Drenac municipality, Ferizaj and other locations in Ferizaj municipality, Gijan in Gijan municipality, Jablanice in Đakove municipality, locations in Kačanik municipality, Klečke and other locations in Lipjan municipality, Likoc and other locations in Skenderaj municipality, Mališeve and other locations in Mališeve municipality, Voljake Cave in Kline municipality, Novo Berde in Novo Berde municipality, / and other locations in Pristina municipality, Prizren and other locations in Prizren municipality, Suha Reke and other locations in Suha Reke municipality, and locations in Viti municipality. And B. Kahan and Kukesh in northern Albania. 3. The war crimes under counts 1, 2, 4, 6, 8, and 10 were committed as part of a widespread or systematic attack directed against the civilian population in Kosovo and northern Albania from at least March 1998 through September 1999. In particular, these crimes targeted opponents who were perceived to have been collaborating or associating with Federal Republic of Yugoslavia forces, officials or state institutions, or otherwise not supporting the aims or means of the Kosovo Liberation Army, KLA, and later the Provisional Government of Kosovo, including persons associated with the Democratic League of Kosovo and persons of Serb, Roma, and other ethnicities. 4. The crimes under counts 3, 5, 7, and 9 were committed against persons not taking active part in the hostilities and in the context of and associated with a non-international armed conflict in Kosovo between the KLA and forces of the FRY and the Republic of Serbia, including units of the Yugoslav Army, police, and other units of the Ministry of Internal Affairs, and other groups fighting on behalf of the FRY and Serbia from at least March 1998 to approximately 16 September 1999. 5. In relation to these crimes, there is a well-grounded suspicion that Mr. Veseli is criminally responsible pursuant to Article 16(1)(a) of the law for A. Committing, as a member of a joint criminal enterprise, the crimes under counts 1 to 10, or alternatively, committing, as a member of the aforementioned joint criminal enterprise, the crimes under count 1 to 10 by being aware that such crimes might be perpetrated in carrying out the common purpose of the joint criminal enterprise and by willingly taking that risk, and or B. aiding and abetting the crimes under counts 1 to 10. 6. In addition, and in the alternative, there is well-grounded suspicion that Mr. Veseli is criminally responsible pursuant to Article 16(1)(c) of the law as a superior for the crimes under counts 1 to 10. Thank you, Your Honor.
Thank you, Madam Court Officer. Mr. Veseli, I wish to remind you that this is not the time to contest the charges, but simply to acknowledge your understanding of the charges. You will have ample opportunity to challenge the charges with the assistance of your counsel. Mr. Veseli, did you understand the charges contained in the confirmed indictment as read out to you by Madam Court Officer?
Your Honor, yes, I heard the charges.
Thank you very much. Now, let me inform you of your rights before this court. The law of the specialist chambers and the rules of procedure and evidence guarantee you a number of rights. I will read out the most important ones. First, you shall be presumed innocent until proven guilty beyond reasonable doubt. In the determination of the charges against you, you are entitled to a fair and public hearing subject to any measures ordered for the protection of victims and witnesses. You have the right to be informed promptly and in detail, in a language which you understand, of the nature and cause of the charges against you. You have the right to have adequate time and facilities for the preparation of your defense and to communicate with the counsel of your own choosing. You have the right to be tried within a reasonable period of time. You have the right to be tried in the presence and your presence and to defend yourself through your counsel. You have the right to have counsel assigned to you and without payment if you do not have sufficient means to pay for it. You have the right to examine or have examined the witnesses against you and to obtain the attendance and examination of witnesses on your behalf. You have the right to have the free assistance of an interpreter if you cannot understand or speak the language used in the court. You have the right not to be compelled to testify against yourself or to admit guilt. You have the right to remain silent, and no adverse inference shall be drawn from your silence. You also have the right to make unsworn statements relevant to the case, and you may appear as a witness under oath. You have the right to lodge preliminary motions to challenge the jurisdiction of the specialist chambers, to allege defects in the form of the indictment, and to seek the severance of indictment. You have the right to receive, within 30 days of today's hearing, the supporting material to the indictment submitted for confirmation. You have the right to receive all statements of witnesses whom the specialist prosecutor intends to call to testify at trial in a language that you understand and speak, namely Albanian. You have the right to receive immediately any information which may reasonably suggest your innocence or mitigate your guilt or affect the credibility or reliability of the specialist prosecutor's evidence as soon as the information is in its custody, control, or actual knowledge. You have the right that all material and relevant evidence or facts in possession of the specialist prosecutor be made available to you before the beginning of and during the proceedings. This right is only subject to restrictions which are strictly necessary and when any counterbalancing protections are applied. You have the right not to be detained for an unreasonable period prior to the opening of the case, to request review of decisions on your detention, and to appeal such decisions directly before the Court of Appeal. You have the right to appeal directly before the Court of Appeal a decision on preliminary motions challenging the jurisdiction of the specialist chambers. You have the right to seek leave to appeal other decisions. Mr. Veseli, you heard the most important rights that you enjoy in accordance with the applicable legal framework of the specialist chambers. Do you understand these rights?
Yes, Your Honor, I understand my rights.
Thank you very much. I also wish to inform you that according to Article 21(5) of the law, you may not represent yourself because you are currently in detention. Representation by specialist counsel is therefore mandatory. It is my duty as pretrial judge to ensure that your right to counsel is respected. To this end, I have noted the registrar's filing informing me of the appointment of counsel and co-counsel. Counsel, can you confirm that you have been appointed to represent Mr. Veseli?
I do confirm that.
Thank you very much. I am therefore satisfied that the accused is presently represented by counsel. I will now turn to the possibility for the accused to enter a plea, if any, in accordance with Rule 92. Mr. Veseli, within 30 days from today, you will be called upon to admit guilt or plead not guilty on each charged in the confirmed indictment. If you wish to do so, you may choose to immediately admit guilt or plead not guilty. I would therefore like to ask you, Mr. Veseli, if you had had the opportunity to discuss the charged in the confirmed indictment with your counsel, if you are prepared to enter a plea at this time. If it is the case, I invite you to stand up while you plead.
Thank you, Your Honor. I heard the charges and I read them. Allow me to say with full conviction that I am not guilty in relation to all the charges in the indictment. Thank you.
Thank you, Mr. Veseli. That is very clear. Now let me move to the working language of the proceedings. In the scheduling order for this initial appearance, I ask the parties to make submissions on the working language to be used in the present case according to Rule 8. Mr. Prosecutor, you already made submissions, but for the benefit of the accused present, if you can reiterate. Thank you very much.
Yes, Your Honor. It is the prosecution's position that English should be the working language of these proceedings.
Thank you very much, Mr. Prosecutor. Counsel.
There is no objection to that course.
Thank you. I will issue an order in due course on this matter. As indicated in the order regarding this initial appearance, I will also schedule a status conference pursuant to Rule 96 to be held shortly after the initial appearance of all the accused in this case. The purpose will be to review the status of the case and organize exchanges between the parties to ensure expeditious preparation for trial. Mr. Veseli, I wish to remind you that you have the right to attend this status conference with your counsel. However, with your written consent and after receiving advice from your counsel, pursuant to Rule 96(2), the status conference may be attended by you in person with your counsel participating via video conference link, by your counsel with you, Mr. Veseli, participating via video conference link, or it may also take place in your absence with your counsel present or participating via video conference link. I will now ask the parties for their views on a suitable date for the status conference to be held on or after Wednesday, 18 November. And would the defense also please indicate whether it plans to participate in persons or via video conference? Mr. Prosecutor.
Again, Your Honor, as the court is aware, we are available at the court's convenience, and that date is indeed suitable.
Thank you, Mr. Prosecutor. Now I turn to the defense. And I see that we have an issue with the video link. Madam Court Officer, if you can check with the audiovisual section, if we can reconnect with Mr. Emerson, please.
Your Honor, the matter is being addressed.
We will stay in the courtroom, hoping that the connection will be repaired quickly. For the parties, participants, and to the public, I am told that it's being currently fixed and we should have the connection back within a minute or so. So we will wait a little.
Can you hear me?
Yes.
Oh, I'm sorry about that, but at least we... Oh, now you've gone.
Mr. Emerson, can you hear us?
I can hear you. There seems to be some problem with the video. There we are. I think we're restored now. Can you hear me clearly?
Yeah, we can hear you very clearly. I think it has been, the video link has been cut just before I was going to give you the floor on the date for the next status conference. Have you heard what the prosecutor said, or do you want the prosecutor to repeat what he just said about the date? Because I don't know exactly when it was cut.
I heard Mr. Teager's response, and mine is essentially the same, which is that we are also at the disposal of the court for a date that is convenient to the court. Likely, we will conduct the status conferences in the interim period by video link.
Thank you very much, Counsel. Duly noted. I will, you will receive a scheduling order that will include the agenda in due course. I will also ask the parties for written submissions on the topic of the status conference. I intend to schedule the date for written submissions of the SPO on Friday, November 13th, as I mentioned already in a previous hearing, and for the defense on Tuesday, November 17th. And after the status conference, I will issue a decision on the specialist prosecutor's disclosure obligations in accordance with Rule 102 and on the redaction regime for the proceedings. At this point, I would like to ask the parties whether they have other issues they would like to raise, and I remind the parties to give prior notice should any submission require the disclosure of confidential information so that appropriate measures may be taken. Mr. Prosecutor.
Thank you, Your Honor. There is nothing further from the prosecution.
Thank you. Mr. Emerson.
I would like, if I may, just to make 4 very short points. First of all, to thank you for reiterating the application of the presumption of innocence in these proceedings and reminding those following them that Mr. Veseli is to be genuinely presumed not guilty of all charges for all purposes as these proceedings continue. Secondly, and following on from that, to give the court notice that an application in the appropriate form will be filed shortly for Mr. Veseli to be released pending trial. As I say, that will be done in writing in accordance with the appropriate procedure. Third point is just to place on record the fact that although reference was made to Mr. Veseli having been arrested, it's right that Your Honour should be made aware, and the public should be made aware, that Mr. Veseli came before the court as the result of a voluntary surrender agreement with the prosecution in advance, so that arrangements were made through counsel for his voluntary surrender. And the fourth and final point relates to the position that Mr. Veseli has taken in relation to these proceedings. And I think it's right, and I'm asked by him to emphasize this, that on the day that he did surrender, he issued a statement, a short passage of which I would like to put into the record. It said this: I have every confidence in the objectivity and fairness of the judges, and I would ask that everyone in Kosovo should show due respect to their judicial authority at all times. The process is there to get at the truth. We have nothing to fear from the truth. There must be no attempts whatsoever to undermine the work of the tribunal or to obstruct or interfere in any way with due process. It must be allowed to get on with the important task we have entrusted to it. The integrity of the process must be respected at all times and by everyone. Justice does not just serve the interests of one side or the other, it serves the interests of the people. So if you are asked to assist the specialist chambers, please do so without hesitating. That way we will all get at the truth. I would therefore ask that all sections of our society respond to this situation calmly and with dignity, confident in the knowledge that the judges will deliver a just result at the end of the process. Please remember at all times that this tribunal was set up by the Kosovo Parliament, acting on behalf of the people. It is the embodiment of the principle that there is no peace without justice and no justice without peace. Although it sits in The Hague, it is part of our own law. There should be no resentment directed towards the internationals who work at the tribunal. They are only doing what we, the people of Kosovo, have asked them to do. This tribunal is part of Kosovo's journey to statehood, and we must see it through to the end. Mr. Veseli wanted me to emphasize that. I think he was right to do so, and that concludes the opening remarks that I wish to make.
Thank you very much, Counsel. Mr. Prosecutor, do you want to add anything?
No, Your Honor. Of course, the prosecution welcomes at any time a number of the self-evident truths just articulated by Mr. Emerson and on Mr. Veseli's behalf. We trust those will be abided by. I have nothing further to add at this time.
Thank you, Mr. Prosecutor. Mr. Emerson, do you want to add anything?
No, thank you.
Thank you very much. Mr. Veseli, I would like to ask you if you have any issues to raise in relation to your arrest, transfer, or detention.
No, I don't have anything to add to the statement just read by my counsel. Thank you, Your Honor.
Thank you very much, Mr. Veseli. Finally, I inform you that I will issue a decision ordering the specialist prosecutor and the registrar to reclassify their filings and prepare redacted versions, as the case may be, so that the defense has access to them as soon as possible. As you remain in detention, Mr. Veseli, I would like to inform you that you may challenge your detention on remand in accordance with Rule 57. This will be dealt with in written rulings. This concludes this hearing. I thank the parties and the registry for their attendance. I also wish to thank the interpreters, stenographer, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned. Thank you.
All rise.